Welcome to the Season 4 of the India Energy Hour podcast. This podcast explores the most pressing hurdles and promising opportunities of India's energy transition through an in-depth discussion on policies, financial markets, social movements and science. Your host for this episode is Shreya J., Delhi-based energy and climate journalist. The show is produced by 101 Reporters, a pan-India network of grassroots reporters that produces original stories from rural India. Can you take your local or national political leader to courts when you face adverse impact of climate change? Can the India Constitution recognise climate change under its section of right to live? These questions were explored in a recent Supreme Court hearing. The said case ruled against the right to livelihood of an endangered bird, but has sparked a debate in the country. What would it mean to have a law against impact of extreme weather events and climate change? To discuss the same, we talked with Shibani Ghosh. Ghosh is an advocate, on record, Supreme Court of India, and a visiting fellow at the Sustainable Futures Collaborative, a new Delhi-based research organisation. As a litigator, Shibani appears in environmental cases before the Supreme Court of India and the National Green Tribunal, a specialised forum for environmental cases. Shibani researches and writes on issues relating to Indian environmental law, regulation and governance. She has authored several articles, book chapters and opinion pieces on environmental issues. She has edited a volume titled Indian Environmental Law, Key Concepts and Principles, Orient Black Swan 2019. Shibani was associated with the Centre for Policy Research, New Delhi, in various capacities from 2010 to 2023.
Hello and welcome to the India Energy Hour. Today we have with us Shibani Ghosh, who's a noted lawyer who has worked on the environment sector, has been part of several noteworthy cases and has been writing on the subject, speaking on it for quite some time. Shibani, we have been trying to get you on our show for quite some time, but I think this was the right time where a discussion has started in this country whether there should be a law, a legislation on the effects of climate change. And we could not think of anyone better than you who could come and talk with us on that. So welcome to the India Energy.
Thank you so much for that very generous, partly undeserved introduction. And no, it's a great pleasure to be on this podcast. You've been doing a fantastic job. And I've come across several of your podcasts and very interesting issues. So I'm looking forward to our chat today, Shreya.
Thank you. Great to have you. And it's a tradition here in this podcast that before we delve into these heavy duty technical topics that we discuss, we want our audience to know who our guest is. I'm sure a broad spectrum of people in the climate sector, environment sector know about you, but I would still want you to leave your humility aside and tell us a little bit about yourself. Where are you from? What did you study? How did you end up into the legal sector and into this very interesting amalgamation of climate, environment and law? So if you can tell us about your journey, please.
Oh, wow. Well, actually, when I was in school, I'm one of the early generation of school students who started working on environmental issues with NGOs in Delhi. So there was this NGO called Development Alternatives, which of course still works in this sector, and they were reaching out to school students to be part of various environmental initiatives, such as water testing and things like that in parts of Delhi and Noida. And I got interested in it from then. And when I was thinking of what I wanted to do after school, I knew it had to be something to do with environment. I just didn't know what I wanted to do. So all options were open for me. Apart from I did not want to do medicine or engineering. But I thought of environmental planning, I thought of architecture, I thought of design. I come from a family of architects and designers. I took a few entrance exams, didn't clear them in design. And then a very close guide, mentor, our neighbor, who's a lawyer herself, she suggested, why don't I take the entrance exam of a law school which had just been set up? It was a year old, the National University of Juridical Sciences based in Kolkata, and had been set up by one of the leading academics, Dr. Madhav Menon at that time. And she said, why don't you just take that entrance exam and see? And this is long before CLAT and common law entrance exams. So we had to take individual exams. And this was before my class 12 board exams. I got through and I'm like, okay, this is where I'm going. I couldn't get I just decided I didn't want to take any more entrance exams. I was happy where I was going. So I joined law in a new institution. We were just the second batch of NUJS. And throughout my 5 years at NUJS, I tried to take on internships and courses which had some engagement and interface with environment. I did, worked with some environmental lawyers. I worked with an NGO. On environmental issues. And then I uh, I also, just to kind of make sure that my decision to pursue environmental law and not to go down the more attractive corporate firm route, I even interned at a corporate firm and decided I was making the right choice of not going down that route. So I was interested in environmental law, but more particularly on the public interest side. Then I was fortunate enough to get good guidance to apply for a scholarship. I received the Rhodes Scholarship and I was able to go and study at the University of Oxford. The Rhodes Scholarship covers at least 2 years at the University of Oxford. So I had this fantastic opportunity to actually do two postgraduate programs there. The first was a graduate in law, which there is called Bachelor of Civil Law. And the second one, though I had an opportunity to continue in the legal field, I just decided I want to do something different. I decided to do MSc, a policy degree in environmental change and management, kind of bringing together my interest in law and environment. And that was really fun because after 6 years, I was not surrounded by other law students. And it was, fantastic because there were so many of us from different nationalities and different backgrounds discussing issues of climate change, biodiversity loss, so many of these emerging and current issues, but from different backgrounds, which is a great learning opportunity for me. And then I decided I want to come back to India. I wanted to come back to India and I wanted to work in the public interest sector in environment, but I couldn't really find what I wanted to work on in. So I actually worked with the Central Information Commission for a year with former Information Commissioner, Mr. Shailesh Gandhi, which was such an eye-opening experience for me because I was working, and the Information Commission, as you know, is part of the Right to Information Act, the agency, kind of the apex body, and to have this opportunity of working for more than a year inside a government setup was. I mean, I would recommend that to anyone who's interested in policy making and wants to engage with government and understand how bureaucratic structures work. I mean, I had a fantastic boss who came from the private sector, so learning was very steep and enjoyable. But at the same time, trying to figure out how, at the end of the day, a government office can work or not work, because there would be at times we couldn't print orders of the commission because there was no A4 size paper available. It had to be, you had to put in a requisition and you didn't know when A4 size paper would arrive in the office. So it was a great, I really enjoyed my time there and learned a lot. Then I had the opportunity to actually start working in parallel, thanks to both the organization and the person I started working with agreeing to this parallel work structure. One with the Center for Policy Research, where I continued to be associated for 13 years. I started working there as a research associate, and finally, when I moved out, I was a fellow, working on climate, environment, environmental governance, air quality, such a wide variety of issues I had the opportunity to work on. I had such good mentors there, Professor Navroz Dubash, Professor Lavanya Rajamani, of course, Professor Pratap Bhanu Mehta, and fantastic, group of colleagues who really, we all of us together, I think, have enjoyed our time at the Center for Policy Research and learned so much from each other. And in parallel, I also started environmental litigation and working in the courts and um, on environmental issues. I've always wanted to focus on environmental law, which is not a choice many lawyers make. Many people want to, experience diverse areas of law, but right from the beginning, I was very focused. I wanted to do environmental litigation. Perhaps in hindsight, I should not have narrowed down so soon in my career, but well, what's done, what is done. So I worked with Mr. Ritvik Datta for a few years, who's, of course, one of the leading environmental lawyers in India. Learned a lot, saw the National Green Tribunal being set up and having teething troubles then. So anyway, that's how my career started, and slowly I moved out, started working independently, taking on cases independently on environmental issues. I I'm now an advocate on record at the Supreme Court of India, for which one has to take an exam, which one at that by that point wasn't used to taking exams, because I don't think any of us are used to writing with our hand for 3 hours anymore. But that was a good experience. So I became an advocate on record some years ago, and I can do my own filings. That's what it means in the Supreme Court. And yes, so that's been my journey. I've had the opportunity of working with some really good people, NGOs, advocacy groups, individuals who are so passionate about their work. And at the same time, through the Center for Policy Research, I've been had the opportunity to do a lot of research, writing, thinking around issues of environmental governance, regulation, where they intersect with climate change. And I have to say there that with Lavanya and Navroz, of course, many discussions, writing on climate change negotiation, policy, decision making, climate institutions. But my interest mostly has been on the domestic side, not so much on the international legal side. And therefore, something like climate litigation or climate law, climate institutions are almost like an organic and natural intersection between my interest in environmental law and climate. And that's how this is an area I have thought about a bit and written about. And now I am also visiting fellow at a newly set up research organization called Futures Collaborative, Sustainable Futures Collaborative, which is set up in New Delhi. It's a young organization, and we are very excited about this research agenda that we've set up for ourselves. And I hope to continue working on many of the issues that I've worked on in past: air quality, climate litigation, climate law, environmental governance, and things like that. So yes, that's me.
No, great. And as you were talking, I realized that some interesting set of choices that you made. One of the foremost being working in the school with in this environment segment, and then choosing not to become doctor and engineer. In my experience, some of the best people that I've met were the ones who chose not to become doctor or engineers. So kudos to you that on that. And yes, congratulations for this new initiative that you and some of my other favorite people also our past guests, Aditya, Navroz, have set up this, and I'm so looking forward to interact with you guys and look at the work that Sustainable Futures Initiative would do. I did go to the website and the handle; it looks absolutely fascinating. So best wishes on that.
I'm so glad. Yes, we are excited. Fingers crossed. But there's so much to do. So many people to speak to and work with and collaborate, and we have collaborate in our name, so we intend to take that very seriously. Yeah, and I think we've Shreya, like you said, we've had a lot of many of us have been in this area and worked in different capacities, and it's been really encouraging to see so many of our friends and peer group being similarly encouraging as you in this new venture. So thank you.
Great. I'd also, talk a little bit about your decision to be into climate and environment litigation. How much of how normal it is in India for lawyers to choose this particular niche segment? How difficult, and if I may say so, how difficult or easy it is for you to be in this particular niche sector? What does it entail? If I can simplify the question, what does it mean to be an environment lawyer in this country in this present day and age?
Right, Shreya. So, I mean, I have to say it's never been easy being an environmental lawyer. I mean, as kind of indicated earlier, the way the Indian legal fraternity is set up, most people don't specialize. Most people who litigate in courts are general practitioners, certainly in the early part of their career. As you move on, then you kind of either specialize or have more interest or get to be known for a particular area of law. So there aren't actually that many people who practice exclusively environmental law. And even within that, Shreya, of course, while I mean, there's environmental law and there's environmental law, right? So, I mean, there's so much within environmental law that you could work on. But there are also many sides of it, if I could call it that. So, I mean, obviously, there are big corporate law firms which uh, also have environmental law groups or units or departments which advise their clients on environmental compliance, on litigation where or help their clients in litigation where, for instance, their environmental approval or their forest clearance has been challenged. So, of course, there are many lawyers who are working in corporate law firms who are extremely conversant with environmental issues. So, uh, I mean, there is, of course, that group of lawyers. And there are environmental lawyers who don't practice in courts and who are researchers or who are in academia and who are teaching. And I must say that there are increasingly young researchers um, and lawyers who are turning back into academia, and perhaps either it's that it could be that there are now more institutions, legal institutions in India, which have job openings which are perhaps attractive, or there are institutions that are headed by people who make working in those institutions attractive as well. So there are colleagues of mine who are teaching environmental law. There's some of us, as I said, who litigate. So it's and another aspect of this is, I mean, I think you were asking me is how easy it is. I mean, it's it's interesting because there's so much happening constantly. There's so much to take say to discuss, think, write about, and at the same time perhaps challenge in court, write representations on. But it's difficult because, and increasingly so because uh, there is, we don't know what the outcome of many cases are going to be. I mean, it's always been unpredictable, of course, but sometimes these cases are, these are not, even if you start a case in court, the outcome could be the outcome in court could be very different from the outcome outside the court, if you know what I mean. So there are so many factors which affect how a particular case would move. And I feel now uh, those extraneous factors, if I could call it, are somehow even more pronounced. And there are a lot of people who would like to approach the court and challenge issues and express their concerns. And I see them not wanting to do that. And there is perhaps fear that they would not get what they want in court, perhaps lack of faith. Perhaps they think that this will just drag on too long and they would not get the outcome that they are hoping for. Or there could just be other reasons that they feel that this may not be the route to take. So, as an environmental lawyer, one has to then try and advise them that, look, these are your options, and be extremely frank with them that, let's be real, this is what could happen, this is what could may not happen, and this could not work in your favor, or this may work in your favor. So, yeah, so that's what one does as a lawyer. Um, and of course, as a public interest lawyer, there's always an issue of, you know, how is this a sustainable profession for a person? And that question is there for everyone who goes into cases or public interest issues which are of socio-economic or environmental concerns, which are not necessarily hugely remunerative. And so those are decisions one has to take for oneself and for one's family, and how you want to define your career.
On the remuneration part, it makes the two of us on our career choices. But interesting, you mentioned a very interesting line, which would be a major takeaway. Definitely, is that what happens inside the court and what happens outside the court, the kind of impact of what happens inside the court could be two very, very different and distinct things. And I think that gives me the trigger to jump into today's topic, wherein a recent Supreme Court order said something very interesting. It was actually an observation. Correct me with the jargons and the technicalities. That Supreme Court said that the citizens of this country should have a right against the adverse effect of climate change. Before we delve into this observation, can you just tell us what this particular case is? How and why did Supreme Court mention this particular very interesting line, which has started a debate?
Right. So, Shreya, this judgment of the Supreme Court that you're referring to, which was delivered in March of this year, actually came about in as a result of a writ petition that was filed some years ago in 2019 by Dr. M.K. Ranjit Singh, who's a former uh, uh, additional secretary to the government of India, I believe. So he's a former bureaucrat, and he had filed a writ petition under Article 32 of the Constitution for the protection of the great Indian bustard and other species, the lesser florican, for their protection, because they are a critically endangered species. Their habitat is mostly in Gujarat and Rajasthan, and the numbers, by some estimate, there are only 125 of them. By some estimate, could be up to 250. But by IUCN's estimates, it's a critically endangered species. And so he had filed a case, kind of praying for directions for the protection of this species. Now, this eventually led to an order or a judgment in April 2021. Now, while there are several reasons why the population of the great Indian bustard has been dwindling over the years, the habitat has been destroyed for many reasons. They lay eggs on open ground, so those are kind of exposed to several risks. But one of the reasons that was coming out quite clearly was they actually don't have these birds don't have frontal vision, so they were actually hurting themselves, often fatally, by bumping into transmission lines that had been laid across power transmission lines that had been laid across massive tracts of land in Gujarat and Rajasthan to from and particularly from solar energy projects. Now, the one key outcome of the judgment by the Supreme Court in April of 2021 was that a huge area of which was basically identified as the habitat of the great Indian bustard, almost 90,000 square kilometers, was declared as a protected, I mean, that had to be protected for reasons of habitat conservation. And the Supreme Court said that, you have to put the transmission lines underground, and you can't have overhead transmission lines because these are really, really dangerous for the birds. Now, the Supreme Court was also cognizant of the fact that in some cases you will not be able to put these transmission line underground, and therefore they set up a committee which would decide on a case to case basis. But the general direction, Shreya, was that that area, that habitat that had been identified for the Great Indian Bustard is may generally be considered off limits unless certain exemptions are identified by this committee, and that's how it was moved. Then certainly ministries, Ministry of Environment Forest, Ministry of Power, Ministry of New and Renewable Energy, approached the court for a modification of this order, this judgment. And among other things, they said that the judgment has vast implications for the power sector and the way that India is planning its transition away from fossil fuels, because it's greatly, in their opinion, hampering the solar energy potential of that area. They also refer to India's kind of international commitments under Paris and a Paris Agreement under the UNFCCC. And they said that, undergrounding of high voltage power lines is actually technically not possible. And if we go ahead with these direction of the Supreme Court, we'll actually be unable to replace coal-fired power plants, which is kind of one of the policy goals that the government of India has. Now, so this kind of application, Shreya, for modification of the order of the 2021 judgment of the Supreme Court is what was before the court. And what the court finally, well, the court says many things. What's interesting about this judgment is that it's a detailed judgment. It lays out what India's position on climate change is. It discusses the Paris Agreement. It discusses the UNFCCC, the preamble. It discusses why solar energy or renewable energy is important. It goes into other kind of how climate change interacts with human rights and could lead to human right violations. So the judgment kind of covers huge ground in that sense. And what comes out of the judgment is, and why it's been considered to be a landmark judgment, is that it's for the first time the Supreme Court of India is identifying a fundamental right, which is emanating both from Article 14, which is the right to equality, and Article 21, which is called the right to life. In shorthand, it's referred to as the right to life, and says that this right to clean and healthy environment, which the Supreme Court previously has on many occasions said is part of the right to life. Another facet of this right to clean environment is this right that, Shreya, as you mentioned, is the right against or the right to be protected from the adverse effects of climate change. And what makes it interesting is that, as I said, it's the first time the Supreme Court identifies this climate right, and not only identifies Article 21, but also Article 14 as a right to equality to be a source of this right. And it gives several examples because it says that climate change is going to impact people differently. So forest dwellers, indigenous communities, people living in Lakshadweep who would, for instance, be affected by the sea level rise caused by climate change, much more than people living in Madhya Pradesh. It will affect women and girls who are often people who are forced with tasks relating to access to energy, cooking, and all of that. The Supreme Court talks about the linkage between air pollution, public health, how many of these issues are going to be affected by the impacts of climate change. So what's interesting is that the Supreme Court talks not only about India's kind of move towards mitigating climate change, talks about India's nationally determined contribution, India's goal to achieving 450 gigawatt of renewable energy by 2030, but it also talks about the impact that India is going to face and how the vulnerable communities are going to be disproportionately impacted, and that India has to therefore create the capacity to adapt to what is in store. So for all of these reasons, it's quite a detailed judgment. It highlights many of these issues. In fact, it also talks about some of the leading climate litigation across the country, including the case from the Netherlands. And then finally, as you said, identifies this right, which I think is in itself extremely significant.
Got it. A very interesting explanation. Thanks for doing that. I also just, wanted to understand uh, this right to life that you're mentioning. Has there been similar precedent? In the past. I'm digressing a bit, but is there a precedent where something as peculiar as adverse effect of climate change, something like that, or something very very different, has been promoted by the apex court in under the right to life?
Yes, I mean this right under Article 21 of the Constitution, which the fundamental right to protection of life and personal liberty, um, has actually been read in many ways, Shreya. I mean, of course, we are talking about in the environmental context, but there are many socio-economic rights which have not been enumerated in our constitution, but which have been acknowledged or read into the Article 21 of the Constitution by the Supreme Court of India and then subsequently followed by various high courts. Uh, what in the environmental context, the Supreme Court has done this in many ways. For instance, it's recognized the right to breathe clean air under the Article 21, right to ecological balance, right to uh, sorry, yeah, sorry, a right to clean hair, clean and healthy environment. And uh, it has used various phrases. Sometimes there's been kind of lack of definitional clarity on what exactly is the right it is defining. But it's the Supreme Court of India has done this before, where it has identified a right, an environmental right. And often, what the Supreme Court has done is it has read Article 21 along with Articles 48A and 51AG, which is which is a directive principle of state policy, which kind of tells the state to protect wildlife, forests, uh, and also the fundamental duty of citizens under the Constitution to protect environment and the natural resources. So these three kind of constitutional provisions are often read by the Supreme Court of India together, along with other provisions such as the right to equality or something like that. On many of these environmental cases where constitutional issues are brought up, the Supreme Court has done this. So, I mean, it's not the first time that the Supreme Court has identified an environmental right, but it's the first time the Supreme Court has identified a climate right as a fundamental right. So that's what's novel about this case.
Got it. Got it. Got it. And what kind of precedent do you think it will set in terms of legal cases, or taking it a little far fetched in terms of a legislation?
So in terms of legal precedent, Shreya, I think this is going to be an extremely valuable judgment because people now approaching any court, whether it's the Supreme Court, the High Courts, say the National Green Tribunal, can now cite this and say, look, I have this right, and I have a right against being adversely affected by climate change. At the same time, because the Supreme Court, perhaps consciously, has given it a very broad definition, because what does it mean not to be adversely affected, right? Um, uh, it could mean many things. So it could mean that I do not want to face the impact of climate change, and therefore there is a duty on the state to ensure that I, as a person, for instance, living on the coast in India, should have some access to infrastructure or some state support, which ensures that my life and livelihood is not affected by the rising sea levels, and therefore the state must ensure that right of mine not to be affected is protected. It could also mean that I, as a citizen or a concerned organization, could go to any court and say that this particular activity or a project or a policy measure is actually going to lead to significant greenhouse gas emission, or could or is not adopting a route which could how do I say that, which could lead to the setting up of infrastructure which is less carbon intensive, and therefore the decision or the policy measure, the alternative policy measure which could be less carbon intensive should have been selected, or that the government has made certain has certain statutory duties which would lead to mitigation of carbon emissions, and those are not being met. And therefore, eventually, at some point, this is going to contribute to climate change, and that would affect my life. So, I mean, there's a variety of ways in which this right could be used in court, and could be, as the word that you use, has significant precedential value. But at the same time, I mentioned the right to clean to breathe clean air, and that's been part of our environmental jurisprudence now for a couple of decades. But we don't breathe clean air, do we? We have this right that has been recognized by the Supreme Court of India, but none of us can really enforce it. So there is a question of when, while I can say I have this right among many other rights, the question of enforcement will remain. And there would also be a question of which other right this right conflicts with. And this conflict, the Supreme Court and Chief Justice Chandrachud, in fact, does touch upon this possible conflict in his judgment, where he says that these conflicts are likely to happen, and we have to therefore be careful when we are talking about climate issues, because it's not just this right against adverse impact of climate change, but there's of course a right to livelihood, there's a right to life, there's a right to access, say, access the forests. At the same time, we have a significant population which doesn't have access to reliable energy. There's obviously, immense poverty, and such other developmental imperatives that have to be considered. So that right will inevitably have to be balanced. And when that right is being balanced, that's where the courts will step in, and we'll have to wait and watch how useful this articulation of the right is.
Right, and as you mentioned, this should empower the lower courts and specifically NGT in a lot of several other cases that would come up, isn't it?
Yes, I think, Shreya, I mean, the National Green Tribunal being a specialized adjudicatory body, if you look at the jurisdiction of the National Green Tribunal, it is very wide, and deliberately so. And therefore, many of these issues or concerns which are conventionally called climate cases, or have been in other jurisdictions, in other countries, being categorized as climate cases or climate litigation, these could very well come before the National Green Tribunal, because the National Green Tribunal has jurisdiction over Environment Protection Act and all regulations issued under it and notification issued under it. It therefore, including coastal regulation zone, EIA notification. It has a jurisdiction over the Forest Conservation Act, which, as you probably know, has been recently amended, and it is one of the first pieces of laws or legislations which actually in the preamble make reference to the net zero target. So, uh, so therefore, these kind of laws which have which the National Green Tribunal has jurisdiction over, many of the climate issues can be brought within these laws, that the NGT would be empowered to decide them. And therefore, something coming down from the apex court really does put this whole climate conversation on a much stronger footing within the judicial fraternity. And the good thing about this, and I say this in many forums, that we don't have climate naysayers or kind of people who don't in the judiciary who say there's nothing called climate change, or who challenge the fact that there is whether there are climate impacts or not. So yes, so in that sense, I think this articulation is positive, and is going to give put the high courts and the National Green Tribunal much stronger footing to take this right, its articulation, its implementation, and its usage in different contexts.
Right. Speaking on behalf of the citizens, what kind of empowerment do you think citizens will get? Do you think it will become a nuisance kind of precedent where, as you were discussing just before we got on this recording, is that will someone use this particular precedent to sue a neighbor saying that they were noisy and they are creating air pollution?
Yeah.
Or do you think that this would be a step towards a very strong citizen driven climate actions where the citizens of this country take their local and national governments to account, asking them where is the future that we deserve?
I think, I mean, I would have a more.
I know it's a very philosophical, rhetorical question, but just your very just your thoughts on
No,
this.
sure, I understand. I mean, I think there is. I would be optimistic, Shreya. I think this can be. Um, I mean, there's always room for litigation and the court route being used or misused or abused. I mean, there's always going to be scope for that. But I think this kind of an articulation by the Supreme Court, I'd be optimistic that people are like citizens, as I said, organization groups, civil society members. I think they are likely to use this to drive climate action more. And when I was talking about how broad the wording, or widely worded this right is, this right can actually be also used by, as it was in this case, as it turns out, by companies, right? So those who are generating power, and they can use it as well. So it's not just the conventional public interest litigation, or the usual environment versus development, that binary. That's not necessarily always the way in which this right may be articulated. So I mean, power generation companies could come use this right and say that, look, we are actually going to we are going to be a very important part of ensuring that this right is upheld and protected, and therefore allow us some form of whatever the approval or whatever it may be. So anyone could use this right, or refer to this judgment and go to court. And as you mentioned in an earlier question, Shreya, this could also open doors to thinking about a climate law, um, and um, and perhaps you were going to come to it later. But since you did ask me about it, I think there have been rumblings that about whether India should have a climate legislation. There have been certain private member bills before Parliament. We, of course, do not yet have a climate law, an umbrella legislation, but there have been ways in which existing legislations have been either amended, or new rules have been framed under them. So, for instance, the green credit rules that have been framed under the Environment Protection Act, or the carbon trading mechanism that's been introduced through the Energy Conservation, the Electricity Act. Correct me, Shreya. uh, we can change that. So those kind of what is called in the academic literature the dispersed upgrade of kind of tinkering with existing laws to introduce kind of climate spaces, or to discuss climate issues, or to push a climate mitigation agenda has already started in India. And the fact that the Supreme Court acknowledges that we don't have an umbrella legislation, yet we have policies in bits and pieces in different areas, it could very well provide us some impetus to move towards a climate legislation going forward.
Right, and as you asked, it's the energy conservation bill that has been
Yeah, sorry.
amended for
Yes,
the carbon
and
credit scheme.
yes,
Yeah,
yes.
no, it's absolutely fine. There's just so many amendments and bills and acts all around. I
Yes,
can completely
but the
understand.
Electricity Act, of course, I mean, all the renewable
Yeah,
energy, the obligations for
yeah,
the generation that comes
yeah,
under the list. So
yeah.
there have been ways in which climate legislation is already part of our part of our law. The question is whether there is a umbrella climate law that's going to come in or not. Yes.
Right. Good you mentioned it, because obviously I was going to touch upon this particular topic as well. A law, as you mentioned, an umbrella law is something that this country misses. This country finally has a net zero target. It's in 2070. We have sent a lengthy set of commitments to the UNFCCC, climate commitments, but none of these have a legal backing or a legislative backing, if I may say so. How necessary it is to have a law of the land for these particular things. There are very few countries which do have, and if they do, then it pertains to just one of the minor issues. Like in the UK, it is about carbon. In some other countries, you might have much better examples to cite. Can you dwell on it for a few minutes?
Yeah, sure. So, I mean, yes, you're right. India doesn't yet have a climate law, and as I said, that there is that there has been discussion for a while, whether India needs a climate law, and if India does need one, what would it look like? Now, Shreya, as you well know, I mean, when we're talking about a climate law, there is such a vast canvas that it would have to cover, right? As many colleagues use this phrase, kind of climate change is kind of all of government uh, kind of a issue. I mean, there's so many sectors which are affected, so many ministries, departments, both at the center and at the subnational level. There are so, I mean, just in terms of the functions, the duties, the responsibilities, how would you design a law that would cover all of that comprehensively and at the same time would be forward looking, because obviously while we're seeing the impacts now, but this is an emerging area. Science is constantly evolving. So, how would one design a law that would work and would work for it for a country like India, which has very specific set of issues, a very a constitution which has a very important federal character. So in that sense, first of all, it's not easy to design a law that would cover this vast gamut of issues. And uh, but at the same time, as you mentioned, there are countries which have gone ahead and done that. But they have mostly been in this kind of regulatory um, the nature of these laws have been very regulatory in the sense as you mentioned, the carbon, like this is how much carbon we should be emitting by this year, and how do we kind of proportion that out and ensure that we um, uh, don't break that limit. But in India, I think the thinking perhaps should be more about how do we make a law which is more enabling, which ensures other things such as coordination amongst ministry, that ensures or facilitates knowledge sharing, which kind of ensures there are spaces in which there is conversation across ministries, but across center and state, then state and the urban local bodies, for instance. So, how can we ensure accountability? How can we ensure proper measurement? So, all of that also can be supported by a law. So, a law need not always be something that's say a command and control mechanism. It need not be something which is always penalizing someone, but it could also at the same time encourage these other attributes of law, which is measurement, accountability, coordination, policy making, setting the agenda, which is based on robust science, there's a cycle, there's kind of a process that's defined, which ensures there's proper deliberation, there's consultation. So, uh, so my thinking, and there are colleagues at SFC who are also writing and thinking about this, is that if we are thinking of a climate law for India, and I think the judgment by Justice Ranjit does give us kind of some hooks for this, we have to think along these lines, that this law has to be something that India can work with. The peculiar legal structure that India has that it fits into that. We cannot import something from some other jurisdiction and copy paste it into a legislation here. And it also has to be something that works with existing laws. So, for instance, you mentioned the net zero target. It's found a place in the Forest Conservation Act as it has been amended in 2023, right? But is our forest regulation and governance set up in a manner in which it will achieve that target? Even though it's in the preamble, just placing it in the preamble doesn't necessarily mean it will be achieved. The rest of the design of the institutions, of the policy, of the rules, everything that follows from a law passed by parliament, all of that has to be thought through, designed. There have to be processes in way that there's a feedback mechanism. If something is not working, we should be nimble enough to respond to what's not working. Or if there's an emerging threat, for if you look at other institutions, our pollution control boards, an area I have worked on, but from the air quality angle, we've had some of these state pollution control boards set up 4 decades ago. Now, some of these would now, in future, be forced to grapple with issues of greenhouse gas emissions. I mean, it's quite possible. The NGT, for instance, has said that the manner in which a pollutant is defined in our law, the air polluter or an environmental pollutant is defined in our current legislation, is wide enough for a greenhouse gas to be included within that. And if that's true, our state pollution control board could very well have the regulatory, could very well be required to regulate greenhouse gas emissions. But are our state pollution boards designed to do that? Do they have the competence, the capacity, the inclination to do it? All of these things have to be thought through, and many of these things can be thought through a law, of course, but of course through careful policy making and decision making as well.
Shibani, thank you for mentioning that. Very important points you raised. But I'll prod you a little bit more. There are already states, especially in the coastal region, which are facing the impact of global warming and extreme weather events. There are states which have already started working in a direction to plan for an imminent future, such as Jharkhand, which has an energy task force, energy transition task force. Then Odisha, which is working on rules and regulations on climate action, and obviously some southern states recognizing the need to have a climate adaptation plan. Can you give us an overview which can skew this conversation into a full circle?
Right. So, Shreya, you're absolutely right that there are already initiatives at the subnational level that address certain aspects of climate change. And you, of course, gave some examples, whether it's at city level or, heat action plans that are being drafted, or certain states are setting up commissions that are going to look at at these issues at the state level. And I think this is a really fantastic positive sign, because I mean I'm not in a position, Shreya, to kind of list the various initiatives, and I'm sure there are other experts on your podcast who've done that and are in a better position to analyze them. But from my perspective, what is interesting is the federalism aspect of climate regulation in India, and the fact that we cannot expect all forms of decision making relating to climate mitigation or strengthening India's adaptive capacity to be taken at the center. We cannot expect, and it should not be, because many of the issues that or concerns that arise, particularly in terms of adaptation, though not limited to that, are very much in the legislative competence or the executive competence of the state or the subnational bodies like the urban local bodies. And they have the capacity, they have they are, first of all, much closer to the affected population. They are the ones who have the legislative competence to regulate those areas. So if you talk about public health, you're talking about water, all of these issues are things that states should be dealing with, and therefore it makes sense, and it's a positive sign that states are taking these initiatives. That is not to say that the center cannot have anything to say in these issues. In fact, the center plays a very important role in, for instance, finance, in ensuring there's knowledge sharing, in giving guidance in planning. all of that, the center can play a very pivotal role. But at the same time, the center cannot or would not be advised, would be well advised not to be encroaching or using the climate peg as a way to start encroaching on the state's space, because the states at the end of the day have a lot of autonomy in decision making and policy making in many areas. And just because these areas interact with climate, and come on, most aspects of our life and livelihoods and our jobs, or everything will be affected by climate, and therefore that cannot be a reason for the center to start legislating or stepping on the toes of the states. So that we do need more and more of these state level initiatives, and that we do have to have this bottom up approach to some aspects of measures that we take in India, and particularly on adaptation. And also on mitigation, I mean, the state level kind of increasing their capacity on the renewable sector to ensure that their reliance on coal-fired plants reduce. So my sense, Shreya, is that these kind of policies, initiatives, and also institution building. I mean, that's one of the things that, I mean, I referred to it when we were talking about possible climate legislation. What is our institutional capacity, both at the center and state, to do a lot of the things that we need to do, we intend to do, we are planning to do? We have to strengthen our institutions. Maybe not necessarily create new institutions. Make sure existing institutions talk to each other, plan together. I mean, you can't have one ministry going ahead with its own agenda or its own policy goals, while the other ministry does something completely different, which might actually be incongruous to the whole climate action plan, if it were. And so things like the state action plans on climate change, they could provide a good platform for states to come at a state level, engage in a evidence-based planning process, perhaps reach out to the center for some assistance, whether through finance or knowledge or some form of hand-holding. But at the same time, take a lead on it, because they understand their own issues or the state peculiarities better than anyone else, and they can prioritize based on their own understanding of their state's situation.
Great. Thank you for summing this up. Yes, I'm sure going forward, I hope going forward, cooperative federalism should pave way for a better climate action plan of the country, of the states, of even local governments. Let's hope that we see that, and I hope that this particular order and the precedent that this has set leads to some positive outcome, is what we can hope to happen. And yeah, but thank you so much, Shibani. This was a great conversation, something very different, very refreshing, that we usually discuss. We haven't discussed the legal aspects, and thank you for shedding light on this and for being so comprehensive on this particular subject. So thank you again.
Thank you, Shreya, for having me. And this was I enjoyed myself. Thank you so much.
Thank you for listening to the India Energy Hour. Subscribe to this channel to never miss an update. To drop us a feedback, visit our website or write to us at theindiaenergyhour@gmail.com. We are on Twitter. You can follow at TIEH_podcast and get in touch with the two hosts at Shreya_J and at Sandeep Pai.